here in the matter of Kazalbash and the Secretary of State for Housing and Community and Affairs.
Yes, Mr. Pindon.
Senior President, your Lordships, may it please you, I appear on behalf of the appellant, the Secretary of State for Levelling Up Housing and Communities, and my learned friend Mr. Brett appears for the respondent, Mr. Kazalbash, the second defendant, the London Borough of Hillingdon, not appearing and not having participated in these proceedings so far.
Yes.
At the outset, I wish to express my gratitude to the court for its earlier, as I understand it, instantaneous compassion. And I must also apologise to Mr. Kazalbash for the resulting delay it has forced him to endure. I regret that it's been my fault as representative of the Secretary of State, and it has not been forgotten that Mr. Kazalbash has endured delay, and I apologise for that.
Well, Ms. Pindon, thank you for what you said. Let me say no more than to reassure you that no apology is necessary.
I am grateful, my lord. Thank you. Now, the question before the court is whether the judge below was right to find the inspector was irrationally concerned with the visual changes proposed when there were no material visual changes to the building, and to restrict the inspector's use of street scene to a definition found in the National Design Guide. The Secretary of State submits that the judge erred because, firstly, the inspector expressed acknowledged in the decision letter that there were no material external changes to the building in issue, and secondly, that the judge himself accepted design was irrelevant to the decision, and so the National Design Guidance was not an appropriate source of definitions nor meanings. Rather, that the inspector properly and rationally directed himself by way of relevant development plan policies, which required him to determine the decision having regard to whether the proposed development would harmonise with local context, including plot sizes and widths, establish street patterns, building lines, and setbacks. Now, at the outset, to set the scene, in this case, predominantly because of the irrationality finding, context is, as it always is, but particularly so here, critical. And my lords, if I repeat information you're already aware of from your advanced reading, please do advance me along. The property in question is number 26 Highland Road, Northwood in London, within the Borough of Hillingdon. The extension to the property itself can be seen in the bundle at tab 11, page 89. There is hopefully a colour photograph there. So it's tab 11, page 89. And one can see the extension to the right side of the dwelling set back from the property frontage. This was granted consent as a subservient ancillary extension to the main dwelling in 2006, and then subsequently Mr. Kazalbash wished to convert this extension into a separate household comprising a 2-bedroom dwelling with associated garden. Because that is a material change of use, planning permission from the council was necessary. Now I point out at paragraph 6 of the judgment, the judge refers to as part of this development to the creation of a doorway and its extension. As I said, that's paragraph 6. But Mr. Brett's skeleton is correct at paragraph 7a. The only change proposed to the extension was the relocation of a window on the side of the second story of the extension to relocate that about a metre forward towards the front of the building. There is, as I understand it, already a doorway to the side of the extension.
So there's an existing doorway, and that would become, as it were, the front door to the the new dwelling.
Yes, my lord. And that application for the subsequent development, the conversion to a 2-bedroom dwelling, was made to the council the 17th of March 2021, and the council's professional planning officer wrote a report to the planning committee, because they were the decision makers in this case, on the 19th of May that year, 2021. He concluded the development would cause unacceptable planning harm to the character and appearance of the area's street scene, and this report is found also at tab 11 at page 77. 77 is where I wish to take the court to. I apologise. The commencement of the report is at page 70, the very beginning of tab 11.
Yeah.
Paragraph 7.07 is the key paragraph. Unfortunately, within that, we have separate paragraphs unnumbered. And it's the fourth paragraph down where the planning officer sets out the key reasoning for the purposes of this court's determination.
Yeah.
It commences the sentence, part of this paragraph, the sentence commencing that part of the paragraph I wish to take the court's attention to, starts at the end of the fourth line down on the fourth paragraph. From number 26, Highland Road, the application site, which is the last property on the bend in the road, all the way to number 96, Highland Road, close to the junction with Cranbourne Road, there is a continuous line of properties with a rigid building line and uniform plot widths, which is replicated by the odd numbers across the road too. This very high degree of building uniformity gives a very strong character to the street scene. By subdividing the plot in half, it is considered that this would have a much more conspicuous impact than at other locations where there is less uniformity in the street scene. Now, pausing there, as a matter of general principle, planning policy and judgment determines what is conspicuous. To a professional town planner, that clearly is not restricted to only visual matters, otherwise planning policy would be an awful lot shorter than it is. Good planning, of course, entails more than just what can be seen by the eye. Out of character use, for example, may well be conspicuous in planning terms.
Sorry, can I understand that? Normally, conspicuous means you can see it easily. You say it has a special meaning.
Not a special meaning, Your Lordship, but in planning policy terms, conspicuous would be something out of character. And character entails more than just visual considerations.
So what does conspicuous mean if it doesn't mean easy to see?
It's conspicuous means out of character where the character is, as here, a uniform, of uniform identity and form and spatial composure. And we'll see that by reference to the policies, my lord. I hope that might flesh out this point. We'll see in the policies, they do refer to issues beyond the merely visual.
Okay, thank you.
Mr. Kazalbash's application was then subsequently refused on the 24th of May. The Council's Planning Committee having agreed with their planning officer. The formal reason for refusal is found at tab 17, page 160 of the bundle. And there we see there is a single reason for refusal. And here the Council finds that application property forms part of a continuous line of properties with a rigid building line and uniform plot widths. It is considered that the proposed subdivision of the property would, by reason of the resultant narrow plot widths, result in a cramped form of development, which would be harmful to the character and appearance of the street scene. And then the Council refers to policies BE1 of the Hillingdon Local Plan Part 1, policies DMHB11 and DMHB12 of the Hillingdon Local Plan Part 2. They also refer to policy D6 of the London Plan, but that fell away upon the inspector's decision, so we don't consider that any further. But the three policies BE1, DMHB11 and DMHB12 remained in play and indeed were the basis for the inspector's decision. Mr. Kazalbash, as was his right, appealed the Council's decision in June 2021 to the Secretary of State on 3 grounds. The first ground was that the resulting plot widths were acceptable, that argument not being, of course, in issue before this court, although for your Lordship's note, if you wish, that argument can be found in the bundle, pages 97 to 99, paragraphs 5.24 to 5.29.
Sorry, you're referring now to the appeal statement.
The appeal statement of Mr. Kazalbash,
yeah.
And that's his first argument under the appeal before the inspector.
And the paragraph references?
5.24 to 5.29, pages 97 to 99 of the bundle. The second reason it is an issue before this court, but just completing the picture before the inspector, the third reason for Mr. Kazalbash's appeal was that it was compliant with planning policy, and that of course is a matter of judgment, not an issue here, nor could it be. But again, for your lordship's reference, that is found at pages 101 to 103 of the bundle, paragraphs 5.2.15 to 5.2.25. The second ground of appeal is, as I said, relevant to this court's determination, and that is at page 100 of the bundle, and tab 11, possibly still open in front of your lordship, page 100, paragraphs 5.2.11 to 5.2.12 are the ones I wish to take your lordship's attention to. We see 5.2.11, just above there is an extract from the National Design Guide, and the appeal statement says the above definition sets out what constitutes the street scene. So we see that argument was in front of the inspector, made by Mr. Kazalbash, and it was said, in terms of the subdivision of the existing dwelling, the application proposes no alterations to the external appearance of the building. As such, the appeal site building would remain in the same condition as present. In this regard, the only alteration is the erection of a fence. Then reference is made to that being permitted in any event under the General Permitted Development Order. And the next paragraph continues, focusing on the street scene as defined above by the National Design Guide. The proposed development would not result in any change to the subject building. This is the argument, therefore, made by the appellant in front of the inspector on what street scene ought to entail in terms of considerations. And so, because no material visual alterations were proposed beyond a rear garden fence, it was argued, therefore, there was no harm to the street scene. And we can see, of course, that the only definition applied was the definition in the National Design Guidance. Now, the extract of the National Design Guidance that Mr. Kazalbash relied on was appended to his appeal statement, but your lordships will be aware the deputy judge also relied on material that was not relied on by Mr. Kazalbash, and indeed material that was not in front of the inspector. And we have added that to the bundle following the deputy judge's decision. It's found at pages 150 to 150, I apologize, to 151 tab 14. To be clear, the Secretary of State is not arguing that it was unlawful for the judge to have had regard to this additional material in its own right, because of course it can be assumed that inspectors are familiar with national planning policy and guidance, and the deputy judge, it should be said, properly checked with counsel before he relied on that judgment. Although, of course, one hopes reliance on external materials that were not before the decision maker is not a usual course of action. We see at page 151 of the bundle, again that's tab 14, at the very right-hand side of that page, top, if it's in landscape format, definitions, and it sets out street scene is the appearance of all the elements of a street, including the carriageway, pavement, street furniture, planting, buildings or structures along its edges, particularly the composition of buildings on each side of the street. And that was the definition which the deputy judge relied on in his judgment. Now, as we've seen from the appeal statement, the appellant's argument in relation to street scene was restricted solely to visual considerations, whereas having seen the council's committee report, and I should add, as is in the usual way, the council's appeal statement relied back on the committee report. The council's argument referred to the impact of a new dwelling in place of the extension by reference to the continuous line of dwellings, the rigid building line, and uniform plot widths. And it was said those factors gave a very high degree of building uniformity and a very strong character to the street scene. So that's the argument in front of the inspector. Turning to the inspector's decision. This is found at tab 11, page 67 of the bundle. We see from paragraph 3, the inspector identified the main issue as the impact, the effect of the proposal on the character and appearance of the area, reflecting the language and the reason for refusal by the council. It's also important to note that the inspector went on a site visit to the property and therefore he benefited from direct first-hand experience of the context of the property in issue and how the proposed development would affect the character of the area, not of course a benefit which the court below or this court have the advantage of. Paragraph 4, we see he sets out in his reasons at the very end of that paragraph, the second line from the very end. Generally speaking, properties here display similar plot widths and lengths and are set back a consistent distance from the road. This creates a strong front building line and a pleasant rhythm in the street scene, which contributes positively to the character and appearance of the area. And then at paragraph 6, he notes the side extension, which would become a separate dwelling, would be set well back from the established front building line of this side of the street, contrary to the prevailing pattern of development.
You've gone past paragraph 5.
I have indeed.
Because I wonder whether we ought to spend just a moment on that. Are you coming back to that?
We can spend some time, my lord, on that right now, since we're there.
Well, there is this whole question of the visibility of the fence to the rear. The judge seems to have accepted that the inspector formed his own conclusion on that, notwithstanding the confusion there may have been over whether a concession was made and if so, what it was. As I read the judge's judgment, he seems to have accepted, doesn't he, that the inspector seems to have accepted that the fence would be visible.
The judge, it's true, and that's not subject to the appeal because the judge, of course, found in any event it wouldn't have made a difference to the decision. But your lordship is absolutely correct. The confusion, the appeal below referenced paragraph 7. I take on board the appellant's point that the fence would only be partially visible. And my learned friend's argument was that that was an incorrect assumption, that there was no such concession from Mr. Kazalbash. And the judge, having noted that there was the site visit and that the inspector would have formed his own view, just as your lordship said, that he did in fact form his own view based on the visibility of the fence or otherwise, and did not rely on the concession that he had ostensibly mistakenly made in paragraph 7, so therefore it didn't make a difference in any event whether he did or did not incorrectly record the appellant's argument.
So when we look at paragraph 5 of the decision letter, we have the inspector concluding there that the addition of a fence to the rear would cause the resulting two plots to appear narrower than the other properties due to the resulting plot forms. This would appear contrived and highlight the incongruity in the street scene. Now, what do you say about the significance of that conclusion?
The incongruity of the street scene, of course, goes beyond what's merely stated in paragraph 5 or 7 and beyond the fence itself, because of course the inspector mentions conspicuous impact elsewhere, as did the council. So it's reading the decision as a whole, this is one element of the inspector's conclusion, but not the determining factor, because we see when he makes his decision in paragraph 8 and summarises all of the relevant aspects in terms of policy compliance, the fence and the visibility or otherwise of it is not mentioned there, and therefore it was the resulting spatial elements which are highlighted in the policy that he had to apply, which he applied in paragraph 8, that determined whether or not it was acceptable in planning terms. So the visibility of the fence did not in fact feature in his conclusions on paragraph 8, but of course it was part of his overall conclusions as to congruity or otherwise. But insofar as there's a reference to the appearance of the plot widths, in fact, they would be narrower. And that was, of course, a matter for the inspector to determine.
Yeah. Right.
And I'm grateful to my lord that that's taken care of some of the points I was making subsequently. So finding, we were at paragraph...
You were going on to paragraph 6, I think.
6, yes, my lord. And in paragraph 6, the inspector has regard to the prevailing pattern of development. Notes that the setback, whilst when the extension had been proposed to the council and found acceptable, he finds that that would have helped, aided, in his words, the extension appearing subservient to the host dwelling when constructed. He goes on to find that in the decision before him, which proposed a separate dwelling as opposed to an extension, the separate dwelling would appear incongruous in the street scene, and then putting all that together in combination, those effects he found would cause harm to the character and appearance of the street scene. We then have the point in paragraph 7, which we've dealt with thanks to your lordship's helpful intervention. So moving on to paragraph 8, this is the key paragraph of the inspector's decision. This is where he summarises the key factors that he found relevant to his decision on policy compliance. And as I've referred your lordships to, when one reads this paragraph, we see he does not include any proposed change to the visual appearance of the building in his conclusion. He refers to the need for development to harmonise with its context, and that this includes building plot widths and sizes, established street patterns, building lines, and setbacks. On this basis, he concluded there was conflict with the development plan, and that consideration, those specific factors to his conclusion on policy compliance, reflect precisely what is set out in the relevant policies, to which I now propose to take the court to. The first one is policy BE1 at...
Right. Just if you could just slow down a little, because I'm trying to take a note of what you're saying as well as listening to what you're submitting. You want us to look at the policies? That's correct, your lord. Right. BE1 then, yes?
BE1, tab 15, page 152 of the bundle.
Thank you. Yes.
So hopefully your lords are there. First page confirms this is the local plan part 1, and policy BE1 refers to the built environment. Says the council will require all new development to improve and maintain, this is the very first line, the quality of the built environment. Paragraph 1, I won't obviously take your lordship through the whole thing. The key parts of policy BE1 are 1, 2, and 7. Paragraph 1 of this policy requires that development should achieve a high quality of design. All new buildings, alterations, extensions, and the realm, which enhances the local distinctiveness of the area, contributes to community cohesion and a sense of place.
Can I ask, why is paragraph 1 relevant? There's not going to be any new building alteration or extension. There's going to be a change of use, as I understand it.
I read that in a broad sense, my lord. So referring to the high quality of design, which enhances the local distinctiveness of the area. Insofar as it's not an absolutely new building, it is a new use within the area, and so that could, taking a broad reading of this policy, apply because it is relevant to a high quality and then also development.
Is it relevant to design? I would read a policy dealing with the built environment, which talks about design of new buildings, to be about how the new buildings are designed, what they look like, and if there's no change to the external appearance of the building, I wouldn't have thought that was a question of design at all. It's a question of use. Am I wrong?
Your lordship, if you read design to refer only to, well, on a narrow reading, your lordship is correct. On a broad reading, your lordship would be invited to take a more nuanced approach to that, looking at design generally. But I appreciate if your lordship considers that design relates only to visual matters, then that wouldn't apply. Of course not, because there are no material visual alterations to the building. But insofar as there is a finding by the council that there is harm to the local distinctiveness because of the impact on character, it would apply.
Looking at the policy itself, when it says at the very beginning, the council will require all new development to improve, that presumably means development in the planning sense of building operations or change of use.
Yes.
So it's covering change of use, but when you get to 1, it's looking at a specific subset of that, isn't it? A high quality design, as my lord says. So that doesn't seem to be covering all parts of new development. It's only covering building operations, or is it not?
The way I read policy 1, it's the application of text that requires high quality, which enhances local distinctiveness, contributes to community cohesion and a sense of place, includes development which affects those factors, which would include a material change of use. There's a broad and a narrow reading to paragraph 1. And if your lordships take a narrow reading that this only applies to design which has a specific building operation aspect and a visual impact only, then I would have to concede that paragraph 1 does not apply. I take a broader reading in that these factors, where they are affected by any proposed new development, change of use, in this case, then it does apply because it does affect the distinctiveness of the area, community cohesion, a sense of place.
I would understand that submission if it said any development must be such as to enhance the local distinctiveness of the area, contribute to community cohesion and a sense of place. That's effectively what your broad reading is. That's not what it says. What it says is, must achieve a high quality of design in new buildings, alterations and extensions. And it does certainly, to my mind, focus on the design of something that's built, the built environment. That's what this part of this policy looks to me as if it's dealing with. But you say that's wrong. What is on your broad interpretation? What does design mean? It includes how you're going to use a building?
It would include the impact of development on character, but there is, insofar as design, the issue here, and I have to be careful with my answer, because the judge below found that matters of design were plainly not relevant. That's his language in the decision. And so I don't wish to broaden the argument beyond that, because it's not necessary to do so, because of course the judge, having found that matters of design were plainly not relevant, we say the National Design Guide therefore was plainly not relevant.
You've got here a strategic policy in part 1 of the local plan. When you go on to page 156, you're into the second part of the local plan, which is the development management policies. And the first one of those, for our purposes, is DMHB 11, headed Design of New Development. And that begins by saying all development, including extensions, alterations and new buildings, will be required to be designed to the highest standards, and then to incorporate certain principles of good design, which include, first, harmonising with the local context, etc. I don't know how useful it is to read these two policies together, but I think it's your argument, isn't it, in part at least, that DMHB 11 brings into the development management context the strategic ambition in policy BE1.
Yes, my lord, that's precisely it. And of course, your lordships will be aware development plan must be read as a whole. And we have a part 1 and part 2 development plan. So just as your lordship has said, part 1 sets out the overarching principles, which is why I invite the court to take a broad reading of BE1. And then the application of the principles within part 1 are set out in the development management policies within part 2.
Before we leave part 1, you focused on 1, and the question is design. Little 2 means all new development,
Yes,
which
I would.
includes change of use and building operations, be designed to be appropriate to the identity and context. I wonder if it's two rather than one. That's the relevant overarching.
I haven't indeed the intention to
Oh, of course,
take
yeah.
your lordships to part
Right.
2, and I rather regret starting with part 1. But part 2 is more, absolutely applies, no doubt, to all development, because it refers to development must be designed to be appropriate to the identity and context. And again, design is broad reading here, spatial as well as visual, to the identity and context of Hillingdon's buildings, townscapes, landscapes and views not relevant here, and make a positive contribution to the local area in terms of layout, form, scale, and materials, latter not relevant here, and seek to protect the amenity of surrounding land and buildings, particularly residential properties, again the latter part not relevant, but insofar as it requires that development, including material changes of use, make a positive contribution to the local area in terms of layout, form, and to some extent scale, that is relevant and applicable to the inspector's decision. I would also take your lordship's attention to paragraph 7, which refers to development which must improve the quality of the public realm, and here I read that as development which would affect the public realm, being the public street and the area's character overall, requires that development, this is midway, about halfway through the paragraph there, respect local character, and next point, integrate with the development. Okay, and
Sorry, what does integrate with the development mean? This is, the council require all new development should do all these things.
yes, my lord.
I understand what it means to say new development should improve the quality of the public realm, and what it means to say should respect the local character and landscape. What does should integrate with the development mean?
Yes, one does wonder if there's a missing word there. It doesn't, on its face, make much sense.
Well, this is referring back, isn't it, to public and private spaces that ...
I see.
integrate with.
I see. Yes, thank you. It's not the new development that should integrate. It's the
Right.
public space, public and private spaces that.
Precisely, it's a holistic approach taken in paragraph 7.
Thank you.
Policy DMHB 11 at tab 16. And this is part 2 of the local plan. So these are the development management policies. Page 156 of the bundle. We see here this requires all development, including extensions, but all development, extensions, alterations, and new buildings will be required to be designed to the highest standards and incorporate principles of good design, including Roman numeral 1, harmonizing with the local context by taking into account the surrounding, and I say the second and third bullet points there are relevant. So new development must harmonize with the local context. In relation to that, one must have regard to building plot sizes and widths, plot coverage, and establish street patterns. And then the next bullet point, building lines and setbacks, streetscape rhythm, for example, and then other streetscape elements. And continuing on, also relied on as being relevant by the Secretary of State. Roman numeral 4, protecting features of positive value within and adjacent to the site. And then completing the policy picture, we have policy DMHB 12 at page 158. Here, this considers streets in public realm. Paragraph A, development should be well integrated with the surrounding area. And Roman numeral 2, and here I interpret this as, again, development should affect the public realm, takes account of the established townscape character and quality of the surrounding area. That's the policy context. Mr. Kazalbash,
Ensures public realm design. That seems to me to be something that's going to be in the public realm, a park or a walkway. But this is just something in the private realm, isn't it?
it is, and the judge had some queries over how applicable policy DMHB 12 was. It's continued to be relied on by the Secretary of State because we take a broad reading that this applies to development which does affect the public realm insofar as the public realm includes the character of the area.
Well, A says development should be well integrated with the surrounding area and accessible, and then it says it should, and it sets out 7 things. But it doesn't say that those are the only 7 things that go into the consideration of whether development would be well integrated with the surrounding area.
Well, we don't have the inspector's precise analysis of what parts of DMHB 12 were relevant, but of course, he could have just applied the first sentence of paragraph A. That is clearly relevant.
Right, thank you.
Now, continuing the factual background, Mr. Kazalbash appealed to the High Court under Section 288 of the Town and Country Planning Act. And the principles that the deputy judge applied are absolutely not in dispute. They are set out by the senior president at St. Maudwin. I don't believe I need to take the court to their own decision.
There's no legal novelty in this case, is there?
No, there is not.
This is, one might say, although important as it is to both parties, to the Section 78 appeal, and no doubt to others in the local area too, it is just about as simple a case in its subject matter as one might imagine.
Yes, that's true, and I think that's probably reflected in the conciseness of the skeleton arguments and indeed the bundle and the legal authorities relied on.
And the question for us is whether the judge was right, ultimately, to conclude that the inspector lapsed into irrationality.
Ultimately, yes, my lord.
And that was what he held. You submit when one reads the 6 paragraphs, actually 5 paragraphs to which you've taken us, there's no trace of irrationality there.
No, not when one looks at the policy context, precisely.
That's your argument. And you say that this was wider than a visual consideration, this went to character as well. Appreciable by sight as it would be, it was wider than, as it were, mere visual impact.
Absolutely, and indeed the judge found that the inspector's decision referred to the visual impact and that it was irrational on the basis that there was no material visual change to the building. But when one looks at the inspector's decision in paragraph 7, he expressly says there are no material visual changes to the building, it was just the fence that he was concerned with. So the judge did not appropriately understand, if I can put it that way, the inspector's decision because he clearly expressed that he understood there was no material visual alteration to the building, and therefore when he refers to incongruity and the factors that influenced his decision insofar as they went to what was congruous or incongruent in the area, it was these wider considerations set out in the policies.
Now, just be sure I've understood. You accept that the development proposal does not involve any material external change in the appearance of the extension. Internally, it becomes a separate dwelling. The only external change is the fence and the subdivision of the plot. Is that, or is that not, visible from the street? Is it something that what would somebody walking past the building see any different after the change of use from what they see today?
I would wish to answer your Lord's question with 2 parts. Firstly, it isn't a matter for this court to determine what the policy merits of that decision were.
No, I'm not about the policy, I'm about the facts. What do you say the inspector found as a fact as to what change would be apparent to somebody walking down the street?
That is set out at paragraph 7, and this is page 68 of the bundle. And here, just as your lord says, there's the fence issue is raised, and then the inspector says no other works are required to facilitate the subdivision externally. And we see he does not mention anywhere else in the decision anything else in terms of a change to the building. He understands there are no other external works that are required to that building. So your lord is absolutely right. In terms of what a person walking along the street would see, nothing. There is a relocation of a window 1 meter forward. One suspects a person on the neighbours might spot that as a difference, but the general member of the public wouldn't consider that a material issue, and it wasn't a factor here. In any event, of course, such a change is development permitted under the general permitted development order, so that no planning permission was needed for that. It falls away. So the only issue in terms of visual considerations was the fence. The inspector dealt with that, and that isn't an issue before this court.
When you say that's not an issue before this court, what is the position with the fence? What do you say? Was the fence, would the fence be visible from the street or not?
If I may refer back to the site visit notes, they were an issue. This was an issue before the court below, and they were appended, and they were in the bundle below. And the inspector's site visit note, and my learned friend will hopefully correct me if I've characterised it incorrectly, says visible neighbours ? And that was the extent of the inspectors, after seeing what the impact of the fence was, that the neighbours would see it. But here, he says, I take on board the appellant's point that the fence was partially visible, but from the site visit notes, the inspector queries that and questioned whether it would be only the neighbours that saw it.
Well, he does deal with this at paragraph 7.
It didn't matter.
He devotes a whole paragraph actually to the fence. And he discounts the fallback position because he judges that it would be unlikely that a fence would be erected in this manner without the proposal to subdivide the plot. And then he emphasises that the fence is part of the proposal. So clearly the fence is playing a part in the assessment that he conducts up to paragraph 8.
No doubt, yes. In terms of what he concludes as being unacceptable in policy terms, and that's where this decision needs to be viewed, that we see in paragraph 8, and we see the fence and the visibility or otherwise doesn't reappear there. So your lordship absolutely right.
Does it need to reappear? I mean, it's a very short letter. He's only setting out 5 paragraphs. They're the crucial paragraphs. He doesn't have to repeat everything. He draws it together in paragraph 8, beginning that paragraph with the words "to conclude."
Yes.
He doesn't then have to recite everything that's gone before.
Of course not.
But everything that's gone before has in fact gone before.
There's no doubt, and if I gave the impression that I was discounting that factor in his decision, if he didn't take it into account at all, it wouldn't have featured in his decision whatsoever. Of course, he considered it relevant enough to have dedicated a paragraph to it. But we see, in terms of policy compliance, I think is the point I was seeking to make, it's not a feature there in terms of the main conclusions of compliance or otherwise with the development plan.
As I understand what you're saying, we're wrong to think about this as a decision that's based on the visual impact from the street. It's not visual incongruity or anything like that. And we should go into a different mindset. If you were to ask somebody, how would you describe Highland Road? You'd say, well, it's a nice road, it's got big gardens subdivided, and it's got houses in a uniform line. If you ask somebody, how would you describe the character of the appearance? You'd say, well, it's got big houses, it's got nice gardens, all set back. Oh, but there's one at the end that's slightly different. It's got a smaller plot and it's set back. And as I understand it, you seem to be saying that that's enough for a change in character. So if the inspector did that exercise, not the exercise of what does it look like from the street, as I understand it, you're saying that is still a change to character of the area and it's up to the inspector. And if you use the word street, it seems better if people didn't use words like that.
Quite.
Or have I misunderstood your submission?
Your Lord, that's exactly it.
That's
yes.
it, okay.
You're correct.
We do meet our old friend planning judgment
Yes.
now and again in this case, don't we? Paragraph 8 he recites the policies. And then he says, at the end of paragraph 8, these, that means the policies, seek, among other things, for development to harmonise with the local context, including building plot sizes and widths, establish street patterns and building lines and setbacks. Those are the features of the policies which he's expressly drawing out as engaged in his planning judgment as to the acceptability of this proposal.
Exactly.
Is that right?
It's that straightforward, my lord. Yes. Exactly.
Right.
Now,
Is there anything more to be said?
having encapsulated my point exactly, Lord Justice Lewis and the Senior President, you have identified what I was going to do in terms of the judgment below. We've been to the policies, we've seen the relevant factors, we've seen the inspector apply them as a matter of his planning judgment in paragraph 8. No issue there with the rationality. The judge's difficulty in understanding the decision arose from his reading of that reference to incongruity and appearances necessarily involving visual considerations. We see that's not correct looking at the development plan policies. So we say, in short, the deputy judge made his decision vastly more difficult than it needed to be. He should have proceeded from the statutory starting point, which is the development plan policies. Had he done so, he would have found that the inspector properly carried out his statutory task, which was to permit development that is in accordance with the development plan policy, or the development plan, unless material considerations indicate otherwise. Refuse development that is not. We say, to conclude, the inspector clearly understood that there were no material visual changes proposed to the building, reference paragraph 7, and he rationally applied the correct policy, it being a matter of planning judgment, and it was therefore wrong to constrain what he could have been referring to when he referred to street scene, to matters of visual appearance by reference to the National Design Guide. He was referring rather to elements of the street scene as rendered relevant by the development plan policies. And on that basis, we say the deputy judge erred, and the Secretary of State respectfully requests that the appeal is allowed. Unless I may be of any further assistance, my lords. Those are the Secretary of State's submissions.
Okay, I'm sorry, I'm being much slower than my lords. Paragraph 6. Side extension will be set well back from the established building line. I understand that. While this may have aided in the extension appearing subservient to a house dwelling when constructed, I understand that. As a separate dwelling, it would appear incongruous in the street scene. Is that a reference to what it looks like, or is it a reference to something else?
Context is critical, my lord, as always. A word can mean very different things depending on context.
What do you say it means here? I'm not asking you to tell me what incongruous means generally. What do you say it means? What did the inspector mean when he said it's okay as an extension, but as a separate dwelling it would appear incongruous in the street scene?
One must not read appear literally.
So appear doesn't mean appear, and street scene doesn't mean street scene?
It means to a planning mind, it's not in conformity. So would appear incongruous means as a planner, this appears to me to be out of character.
It doesn't mean somebody walking past would say, oh, that sticks out a bit because it's set back.
It's a town and country planning issue. And so I appreciate as a member of the lay public, one's concerned with, well, there isn't a visual change here. And I think this is possibly where the judge...
Well, I have to say, I am not surprised. The judge read that, because I read it as meaning, if you were walking past and you saw it was a separate dwelling, you would appreciate that it was out of character with the area because it was set back, and none of the other buildings are set back. But that is a reference to somebody walking past and seeing that it's a separate dwelling. And where the judge, I think, was coming from, you said the judge made it complicated, but I think the inspector hasn't helped himself, because where the judge, I think, was coming from was saying that you read paragraph 6 with its reference to something appearing incongruous. That must mean somebody walking past, appreciating it's a separate dwelling and thinking that that's out of place. But you say that's not what it means at all.
Well, in terms of language alone, one, in general, of course, the inspector, first of all, is not a lawyer, and this is not a contractor statute. It wasn't drafted with that care. And so looking at the way language is used generally, we can often hear people referring to, you appear to be correct. We know that that's not referring to anything visual at all. And so here, the inspector is using common language. It appears incongruous because to him as a town and country planning expert, the spatial aspect of this, having regard to what's relevant in the development plan, is incongruous because of, as you said, my lord.
So appear means seem. It doesn't mean have the appearance of. It means seems. It would seem incongruous.
One could replace appear by be, and it would mean the same thing as the inspector's
Would
intention.
be incongruous. And in the street scene, yes, I see.
Well, you've got to look at 6 as a whole, haven't you? Because that's the end. It says the side extension, which would become a separate dwelling, would be set well back from the established front building line of this side of the street, contrary to the prevailing pattern of development. And while that may be all right if it's an extension, it appears incongruous. It seems to be incongruous. I wish I hadn't used the word street scene. What does scene mean? It sounds terribly trendy, but it's meaningless. All he's saying is in the past, if it was an extension, you could have lived with it. But now it seems, as my law says, out of place
Yes.
in this street.
They are two different questions that were before the council and the inspector in due course. As an extension, it's part of a dwelling that's already there, and subservient, the inspector said it's understandable that was acceptable in planning terms. But what's being proposed here is a brand new dwelling where one does not exist before. And to him, in spatial terms, in terms of the character of the area, the location and impact of that development there was incongruous.
I mean, there is, of course, another way of looking at this, isn't there, which is to read paragraphs 5, 6 and 7 together.
Yes.
Not neglecting the sentence in paragraph 5. However, the proposal to subdivide the plot and the addition of a fence to the rear would cause the resulting 2 plots to appear, note the word, narrower than other properties due to the resulting plot forms. This would appear contrived and highlight the incongruity in the street scene. Then he goes on to say what he does in 6, and then he goes on to say what he does in 7. And that's the core of the decision-making reasoning, which builds up to paragraph 8 to conclude.
Yes.
And for good measure, the final sentence of paragraph 8 sets it out in a single sentence.
Exactly. And so one sentence and one word indeed out of context might, and read too literally in light of the entire context of the decision, especially the concluding paragraph sentence of paragraph 8, makes it clear that he wasn't referring to visual considerations, because he can't have been. He understood from paragraph 7 that there wasn't any external visual changes to the building that were material for him.
I just wonder if this isn't a classic example of the dangers of using 2 words when one would do virtually. If he said street, we'd know what he meant. It'd mean Highland Road, it'd mean the area of the street. But when you go into street scene, it may sound trendy, but you think, oh, what's the scene? And then you get into design and things which may or may not be what the inspector was getting at. But I do wonder whether there shouldn't be new guidance saying, think carefully, use 1 word, if 1 word will do. Anyway.
My lord, you're quite right, and indeed one has some sympathy with the judge, because looking at this, what does he mean by street scene? There's a definition here in the National Design Guide. One can understand the impulse to do that, but it's incorrect, because looking at this decision, and indeed as the judge found, national design was not design. This was not a design case. There is no visual change to the building, so that exercise should not have been undergone. Street scene should be read in context and not as we lawyers would have it mean, which is something precise.
Well, what we do know is that whatever street scene meant in the inspector's mind, it was something that had both a character and an appearance for his purposes.
Yes, exactly.
Can I go back to paragraph 5, where he says it would cause the resulting 2 plots, as my lord pointed out, to appear narrower than other properties. Is that a visual reference?
Well, in fact, they would be narrower.
Yes, but so why does he say would appear narrow?
As my lord said, the danger of using three words when one would do.
This is using a longer word where a shorter one would do. If he said to be narrower and would be contrived, you could cut this down by lopping off seen and changing appear to be. Because that's what he means, I think, isn't it?
Yes.
Be narrower than other properties. You can't appear narrower. You either are narrower or you're not. It's a physical thing. I'm either fat or I'm thin.
Or maybe he simply means that when there's a change in character, you discern it.
Yes, and certainly as a planner, one can understand that interpretation.
A discernible change in character. That's not what he says, but
Unfortunately,
it
no.
may be a realistic paraphrase of what he says.
Yes,
Reading the decision letter as a whole.
exactly. And then applying his judgment.
For planning purposes, who does it have to appear to? Who does it have to be discernible to? Is it to somebody walking past, or is it to neighbours who can look out of their back windows and see, or is it to the people living in the houses? I mean, does it matter whether that is discernible from the street, or from neighbouring properties, or only from the subject property?
If this were an amenity case, then it would be the public and or neighbours. This isn't an amenity case. So when one refers to what's something being discernible or apparent, this means in planning terms, and you have to look at the policies, and those have set out what the relevant factors in terms of what appears to me acceptable or unacceptable. So, Your Lordship, no, in short, it's not restricted to only what can be seen by the public. It's a broader consideration as established by the policies of what is acceptable in this area, in this context, and having regard to the uniformity of the built development, the spatial location of all elements of the street and the houses along that street. That's where the appearance becomes relevant. So in the head of a planner.
Okay, thank you.
Thank you very much, Ms. Pindle. Yes, Mr. Brett.
May it please your lordships, I appear on behalf of the respondent, Mr. Kazalbash, in person, who sits behind me. My skeleton argument appears at page 31 of the bundle. And if I might begin, your lordships, with what we submit is the appropriate way to read this decision, the 5 paragraphs in question, because that seems to me to be of crucial importance here as it was below. Before we get there, though, I'd like, if I may, to emphasise the reason for refusal by the local planning authority set out on page 160 of the bundle, which on line 4 of the reason for refusal states quite plainly that the development would be harmful to the character and appearance of the street scene. And I think it's important that that phrase appears right from the outset. It's not a throwaway phrase or word used to add complexity to what might otherwise be a simple point. It's a word that's chosen. Then if we go to the decision of the inspector at page 69, we say that it should be read in this way, and these submissions you will note, I set out at paragraph 18 of my skeleton argument below as well, at page 129 of the bundle. So, firstly, the inspector at paragraph 3 identifies the main issue is the effect on character and appearance of the area. It's quite obvious that's a more broad concept than the thing in the reason for refusal. So it's not quite right, as my learned friend says, that main issue reflects the reason for refusal. He says character appearance of the area, reason for refusal says character appearance of the street scene. Then in paragraph 4, the inspector explores what contribution the street scene on this road makes to the character and appearance of the area. So first, on the 4th line of paragraph 4, this part of Highland Road comprises a mix of semi-detached and detached dwellings. Generally speaking, properties display similar plot widths and lengths and are set back a consistent distance from the road. These are physical characteristics of the road, of the road. He then says, this creates a strong front building line and a pleasant rhythm in the street scene. So he then takes those physical features and he says, this is what the street scene is like. And then he says...
Well, that's not what he says, is it?
The similar... that is, my lord, in our submission, what he says. He says
it creates a strong front building line and a pleasant rhythm in the street scene, which contributes positively to the character and appearance of the area.
Yes, my lord. And the street scene, the strong front building line and the pleasant rhythm in the street scene are those things which then contribute to the character and appearance of the area. So it's like a pyramid. He identifies physical features at the bottom, their contribution to the street scene in the second level, then he identifies how the street scene contributes to the character appearance of the area. It's quite clear in our submission that the street scene is a component part, in the inspector's mind, of the character and appearance of the area.
Because generally speaking, the houses are the same plot gardens sizes, and generally speaking, the houses all have the same frontage. Generally speaking, he's talking generally there, isn't he?
That's correct, my lord, yeah.
And he's saying if you walked along it, they'd all be pretty much the same.
Yes, my lord. And in our submission, these features are those, as you say, my lord, which are experienced primarily in a visual fashion. And then the inspector goes on to identify two factors which combine together to form the harm with which he's concerned. And we can see why that is, because at the end of paragraph 6, if we dot forward a second, the inspector says in the penultimate line, in combination, these effects would cause harm to the character and appearance of the street scene. So he's chosen again to use the word street scene rather than area.
But his character and appearance.
Yes. And the two factors in combination are the two factors he identifies in paragraph 5, firstly, and paragraph 6, secondly. You can see they're different factors because at the beginning of paragraph 6 we have a conjunction, moreover. So he says there are two factors, in combination they result in harm to the character and appearance of the street scene.
Do you accept that when one reads paragraph 5, it's clear that he is regarding the addition of offence to the rear, which he says would cause the resulting two plots to appear narrower than other properties due to the resulting plot forms, means that he must have concluded that the fence would be visible?
Our submission below and what we maintain is that the inspector incorrectly thought that my client had accepted that the fence would be visible. So yes, the predicate of paragraph 5 is that the fence would be visible.
Well, he doesn't refer at all there, does he, to the appellant's concession or otherwise. That paragraph 5 does say, doesn't it, the addition of a fence to the rear would cause the resulting two plots to appear narrower. And that's unqualified, isn't it, by reference to any concession?
I don't think I would agree with that, my lord. We have to read this, as we've reminded by my learned friend, as a whole.
Of course.
Just because the concession is recorded later, 2 paragraphs later, does not mean it's relevant to that finding in particular. We say that the inspector erroneously took it as that's what we said below, and I'm not here to argue that ground again, because that's been disposed of, but erroneously formed the view that everybody accepted that the fence would be visible, and that's the basis upon which he then reaches a view about the impact of that fence on the street scene, which is what he identifies. And I'll come on in a second to why we say that that word street scene, which he's chosen to use, has a particular significance in this case.
I'd read it slightly differently. I'd assumed from paragraph 5 that he thought it did have an effect, that it was visible, the fence, and that the argument at 7 was how visible it would be. And he thought the appellant, Mr. Kazalbash, was saying it would only be partially visible. So he's saying, I accept that it's not visible everywhere from the street. It's only a bit of the fence that will be visible from the street. So that's what I thought the misunderstanding of the concession. Mr. Kazalbash was saying it's not visible, as opposed to partially visible. And the inspector was saying, well, I think it's visible, and I know that Mr. Kazalbash is thinking it's only partially visible. But that was just the way I read it, but I might have misread it.
My lord, either way, I think it goes to the same point, which is that paragraph 5 is predicated on the inspector's view that whether or not he himself concluded from his own site visit, or he recorded it as a concession from the appellant, that the fence would be visible.
Yeah.
And so paragraph 5 proceeds from the premise that the fence is visible. And then he goes on to say that that fence and its effect, and I'll come on to the word appear in a second, in some more detail, would appear contrived and be and highlight the incongruity in the street scene. So again, that's one factor adversely affecting the street scene. The second factor adversely affecting the street scene is the matter in paragraph 6 that this appeal is mainly concerned about. And the inspector says that by virtue of a change of use to a separate dwelling, that dwelling would appear incongruous in the street scene. So those are the 2 factors he identifies, and then he draws them together to say, in combination, these effects would cause harm to the character and appearance of the street scene. And that's the only harm identified in this decision, is that last line in paragraph 6, harm to the character and appearance of the street scene. And it's in that context, my lords, that we should take paragraph 8. Because when the inspector says the proposal would harm the character and appearance of the area, the only thing he's identified as causing that harm is harm to the character and appearance of the street scene. And it's quite clear in our submission that the inspector uses those 2 words differently.
Sorry, which 2 words?
Street scene and area.
But however he's using them, he's not focusing solely on appearance, if visual means appearance, because he uses character to refer to the street scene as well, doesn't he? So it must have something other than purely visual connotation.
We don't agree, my lord, with that, obviously, otherwise we wouldn't be here. But with that in mind, that's how we submit this decision should be read. If I might now come on to my...
Well, what you submit is, we mustn't get excited about character. when you look at the two factors were actual visual. So if he's referring to character and appearance, I imagine your submission would be when he said two factors and they're visual factors only, thereafter, when he says character and appearance, it must mean appearance, because those are the only two factors that he's identified. That, I imagine, is your submission.
Yes, my lord.
If there is a change to the character of an area, I'm removing ourselves from the facts of the present case for the moment. If there is a change to the character of an area, how does one appreciate that?
That can be appreciated in a number of ways. So, for example, there might be a spatial character that's based upon density, for example, that one might assess having regard to aerial photographs. There might be a change in the composition of different uses in an area, which is based on assessment of those uses independently. And so if you introduce more commercial uses into an area, then that will result in a change in character of the area. There may also be an aesthetic character to an area that will be based, we accept, at least partially and importantly on appearance, because aesthetics is a matter of form and shape and how pleasing it is or otherwise to the eye. So there are a number of different ways in which character can be assessed. And yes, we accept that not all of them are visual. But in this case, as we'll explore in more detail, all the elements we say, and all the wording, and all the terms that the inspector uses are visually focused. And to suggest otherwise in our submission makes it more complicated. My learned friend suggests the judge below has made things more complicated by taking the inspector's words at face value. But in our submission, as I will come on to, it's the attempt to rewrite the inspector's decision, to replace the word appear with be or seem, to insert words there that he didn't use, or to take words like seen out that he chose to use. That's the kind of overcomplicated and overly intrusive approach that should not, in our submission, occur to an inspector's decision in these contexts. So, if I might, your lordships are quite clear on the areas of common ground between the parties, but before I make my two primary submissions, as you will have seen, the respondent's position consistently from the time at which we made our appeal against the determination of the local planning authority was to say that where there is no material exterior change to the building, there cannot be a situation in which a building can suddenly become incongruous when it's been safely there for 14 years already. Interior alterations to a building, which is an established part of a street, cannot overnight render that building somehow out of keeping. And so, in our submission, really the main issue here, however the Secretary of State wishes to put it, is on the proper reading of the decision letter, was the inspector's identification of adverse impact on the street scene and impact in visual terms? If the answer is yes, then the Secretary of State must accept that the appeal fails and has made concessions below to that effect. And if the answer is no, then the appeal should be allowed. And a subsidiary issue to that main issue, which feeds into it, but in our submission is not determinative, is when the inspector refers to street scene, what does he mean? So those are the two issues. I'm going to make submissions on each of those points. But before I do so, I want, if I may, make 3 very brief points on the principles of law here, not to get into St Modwen, but to make 3 points of emphasis, if I might. And your lordships will be very familiar with St Modwen, so I don't need to take you there. But one of the fundamental principles in subparagraph 1 of paragraph 14 of St Modwen is that inspectors' decisions should be construed in a reasonably flexible way. And sometimes this is glossed, your lordships, by the word reasonably benevolent. I don't know whether that adds anything. But the obvious point in our submission is that it's the inspector's decision, as recorded in the decision letter, that's being construed in a reasonably flexible way. And that decision is a formal decision. It's a considered statement of reasons by an experienced professional decision maker. And so the starting point always has to be, well, what did he say? His actual words that he uses in the decision letter. We can't rewrite the decision for him to make it better, much as one might want to occasionally. That's the first point of emphasis. The second point of emphasis is that in subparagraph 6 of paragraph 4 of St Modwen, that it's reasonable to assume that national planning policy is familiar to an inspector. And just because it's not expressly referred to in the decision letter, doesn't mean it hasn't been taken into account. And the other side of the coin to that is that if there's national planning policy that is relevant and before the inspector, and the inspector doesn't say that he hasn't taken it into account, and doesn't give any reasons why he hasn't applied it, he should be taken to have had regard to it and applied it as necessary. And then the third point of emphasis is, again, a presumptive approach that the court takes, which is that where there is material before an inspector or another decision maker, it's reasonable to assume that it has been taken into account unless there's evidence to the contrary. So evidence like that might have been where the inspector says that he hasn't taken it into account or reaches a conclusion that's wholly contrary to a piece of evidence that from that lack of reasoning about why he's rejected it might suggest that it hasn't been taken into account. So those are the 3 points of emphasis, and you can see where they're going, I hope, your lordships. So that then brings me on to my 2 submissions. The first submission is that the words used by the inspector in the decision letter, as the judge found below, demonstrate that the inspector was concerned with the appearance of the development.
Visual appearance.
Visual appearance of the development. And the second submission will be that the inspector's references to street scene are a considered reference to a primarily visual concept set out in the Secretary of State's own policy. So, on the first submission then, your lordship, in our submission, on a plain reading of the words used by an inspector without any glosses or artifice, it's evident that he is thinking in visual terms in this respect, in respect to the subdivision of the dwelling. His finding is that the extension, if used as a separate dwelling, would appear incongruous in the street scene. What does appear mean? The inspector doesn't say it would be incongruous. He doesn't say it would seem incongruous. He says it would appear incongruous. And appear relates to the appearance of something, the way it looks to the observer. It's a plain and ordinary English word. But what did he say it would appear? It would appear incongruous. Incongruous, out of keeping. It would look out of keeping. It would appear incongruous. That is the only appropriate way to paraphrase that finding, which doesn't add anything or take anything away. And the same point is emphasised by how the inspector thinks about the change that's happened. In that same paragraph, previously, when that building was an extension, it would appear subservient. It wouldn't look like another main dwelling. It would appear to be what it is, which is a subservient extension to the host dwelling. That's the same. It's the same word. When it's an extension, it looks like an extension. But now it's a dwelling, it would look different. But that's the irrationality, because it wouldn't look any different. Indeed, there would be no change at all. Again, that's the irrationality. So we say, no glosses, no replacement of words, take this professional decision maker at face value, using the words that he's chosen to use. When we do that, it's plain he's thinking in visual terms. Our second submission will take a little bit longer. It's about street scene. Now again, as I prefaced, my lords, in my description of how we say the decision ought to be construed, the inspector has chosen to use the word street scene sometimes and chosen not to use it other times. So he clearly thinks it has a particular meaning. Otherwise he wouldn't have chosen to use it. And the appellant says in paragraph 22, and in of her skeleton argument, and indeed in oral submissions today, that, or less so in oral submissions, we sort of skipped over some of those points. But in the skeleton argument, the Secretary of State at paragraph 22 says that when the inspector says street scene, he is applying the broader concept of all the elements of a street scene as set out in development plan policy. The problem for the Secretary of State here, though, is that the phrase street scene doesn't appear in the development plan policies. It's not a phrase or a concept that appears anywhere in the development plan policies. And we can go to those, but I should be pointing out an absence rather than a presence. A policy BE1.
Well, I mean, we can take it, can't we, that it's not there if you're telling us it's not there and nobody suggests that it is.
No one's suggesting that it is.
Then we don't need to look at the policies to see that it isn't there, I don't think.
I'm
I think it's common ground, isn't it, that it's not there?
I believe so, yes, my lord. So, in that word used by the local planning authority in refusing planning permission doesn't appear in any of the policies it cites. And it's in that context that the National Design Guide arises. Because it's cited in the reason for refusal, it's not in development plan policy, so my client has to say, well, what does this word mean? And in its appeal statement...
Sorry, should we just look at the reason for refusal?
Yeah, it's at tab 17, at page 160. I took your lordship to this right at the beginning of my submission. The fourth line down would be harmful to the character and appearance of the street scene.
Yes. No, I thought you were submitting that the National Design Guide was referred to.
No, indeed. So the local planning authority refers to street scene. So my client wants to appeal that decision. It looks in the development plan policy in vain for what that word means. And so he goes to the Secretary of State's own policy and finds a definition. And we can see that. My learned friend took you there before. It's at page 100 in the bundle behind tab 11. And in very succinct submissions, which largely reflect my submissions today, my client identifies the definition in 5.2.10. 5.2.11 identifies that there will be no alterations to the external appearance of the building. As such, the appeal building would remain in the same condition as present. 5.2.12, applying the definition in National Design Guide, the proposed development would not result in any change of to the subject building that forms part of the street scene. And then 5.2.13, the point at the heart of our position, it is unreasonable to ascribe harm to the street scene if the appeal scheme would not result in any alteration. It's not like nobody was on notice that that was our position. It's been our position all the way through. So we say, Secretary of State, this is your guidance, this is your definition, this is the meaning of the word.
Can I just check? The inspector doesn't refer in his decision letter to the National Design Guide. He does refer to the framework, and I'm just puzzled why nobody is referring to 150 and 151, because that's the National Policy Framework, and there's a similar definition of street scene there in the little box on the right-hand side. Why
That's the National Design Guide.
Oh, this isn't the National...
That's the National Design Guide.
Ah, because on page 150...
That's an earlier page of the National Design Guide. That's the immediately preceding page of the National Design Guide.
So when it says National Planning Policy Framework chapters, top right hand, it's not the NPPF.
That's giving the reader of the
It's
Design Guide references to the relevant
so
parts.
it doesn't appear in the National Planning Policy Framework then, the phrase street scene definition. Right.
Not to my knowledge,
in the
my
National
lord,
Design
but Miss
Guide.
Bindham, I think, is going to check for me. But we didn't say to the inspector,
No.
look at the NPPF for the definition of street scene. So I suppose to that extent it would be a little odd for me now to suggest that...
Well, then it does make sense, because he does refer to the NPPF paragraph 2. He refers to various other things, but he doesn't refer to the National Design Guide. And you'd have thought that if street scene was critical and he was searching around for a definition, would we not have expected to reference the National Design Guide? Or you say it's not necessary because he's using it and there's no other definition of it?
Yes. But there's a more complicated point underpinning that. Is no one took any exception to the appellant proposing that definition. So it wouldn't be a matter of controversy that one would necessarily expect to be in the decision letter, because everyone seemingly no one had taken issue to that definition. So we submit that the inspector was proceeding on an uncontroversial position, and that then dovetails into those presumptions that I identified from St Modwin. The inspector is presumed to be aware of policy, of which the National Design Guide forms part. He's presumed to take into consideration material placed before him, including the National Design Guide and our submissions. Yeah. And when he explains his decision, he repeatedly refers to adverse impact on street scene. And that's not a generic word, it's a term of art that's defined in the Secretary of State's policy, and that he should be presumed, in the absence of any indication to the contrary, to be applying.
Can you just help me with one thing, Mr. Brett? I'm looking at the definition of street scene in the National Design Guide on page 151, which contains the concept of the composition of buildings on each side of the street. If you just hold that concept in mind and come back to the decision letter, would considerations such as front building line, rhythm in the street scene, plot forms, building plot sizes and widths, established street patterns and building lines and setbacks, would those considerations come within the ambit of composition of buildings on each side of the street?
Yes, my lord.
The matters to which the inspector has found harm?
Yes, my lord.
Thank you. That's very clear, thank you.
Because the National Design Guide definition is clearly I'm repeating my learned friend's point a little bit, but quite a broad one. But it's about all the factors which go together to create the appearance of all the elements of a street.
Yes, that's very clear, thank you.
So our submission is in those circumstances where that definition has been offered and applied, it's not been objected to, and it's part of the Secretary of State's policy which the inspector should be assumed to take into account. Our submission is it cannot reasonably be suggested otherwise than that the inspector, when he was referring to street scene, was using it in the sense defined in the Secretary of State's own policy. The appearance of all the elements in the street scene. And that is a visual concept. Primarily speaking, it's a visual concept.
But what then do you say to the proposition that the inspector, supposing he had in mind the National Design Guide definition, which was referred to, I think, in Mr. Kazalbash's appeal statement, appears to have found harm to elements that would fall within the ambit of composition of buildings on each side of the street as a matter of planning judgment.
That is an element of street scene, and street scene itself is an appearance matter.
Well,
and he's taking this assessment, my lord, in the context of no additional development.
yeah, but my question says never mind. My question says never mind that. Just look at what he's actually decided. What he's actually concluded. When he refers to harm to the character and appearance of the street scene. He's referring to these matters of plot form, building line, street pattern, setback.
In paragraph 6, he says,
In combination, these effects would cause harm to the character and appearance of the street scene.
but that conclusion needs to be put in context, my lord, of there being no change to the building. So that setback, which is identified, again, this gets to the heart of the.
Well, it's not
of the
about the
difficulty.
building. It's about rather more, isn't it? If you look at paragraph 5, not simply the building itself. He's talking about plots, not just the building itself. I mean, what do you say about that?
Indeed, my lord. That's why I think it's important to read this decision in the way that I identified it.
I'm only using his words, you see.
Yeah. The inspector identifies at paragraph 5 the effect, he says, of the fence, and at paragraph 6 the effect, he says, of the change of use from one dwelling to two dwellings. And if, and it wasn't argued below, my lord, but as a matter of materiality, of substantiveness of this error, if the inspector had identified only 2 elements of harm, and one of those elements went away because it's irrational, i.e. The fact that subdividing a house internally might have a visual impact, and he was left only with a partially visible fence visible from the street, he very well may have come to a different conclusion on the acceptability of the development. That's why it's important to take each of these factors as expressed in the decision letter.
Do you accept that the inspector found the fence would be partially visible from the street, and that the judge found that he was entitled to come to that conclusion?
As I think reply, my lord, to Lord Justice Lewis's question, in our submission it's plain that the inspector proceeds on that basis, yes, that the fence would be visible at least partially when viewed from the street.
So that's what the inspector did. And do you accept that the judge took the view, leaving aside your client's supposed concession, nevertheless, he had material on which he could come to that view because he'd been to see it himself?
Yes, that's the force of Judge Below's rejection of that ground. So the error identified on that ground that was accepted was that there was an immaterial consideration, i.e. our supposed concession, but the judge went on to say, well, the inspector went to the site and could reach his own view, although we don't have it very well explained to us on the visibility or otherwise of the fence.
And if you can see even partially the fence from the street, you can read the fact that there's two gardens, because you see the fence. Is that not right?
I think with an expert eye you might, but you would just experience a fence where there wasn't one before.
Yes, but when, I mean, people don't put fences, most people don't put fences down their own back garden. Most people don't have large enough gardens to subdivide them. So mostly when we see fences in back gardens, we read that back into the building and say these are two separate buildings. And if you can do that, why can't you say, well, that's a bit odd because this one is set back. None of the other houses in the street are set back. In other words, once you accept the inspector was entitled to take the view that you could see even partially the fence, why doesn't everything else just follow?
Because that's not the way he's expressed his reasoning, my lord.
Well, isn't it precisely the way he's expressed his reasoning?
No, my lord. He clearly identifies two types of harm, two harms. The first harm is the fence harm, and the second harm is the subdivision harm.
I understand that, but 5, he is talking about, once you see the fence, then you appreciate the plot's been subdivided and you end up with these resulting plot forms which look narrow. I'll accept that appear there is a visual word. Accepting you're right about that. Somebody walking past can see the fence, and so what they read in the street scene is we've got two rather narrow back gardens. Now, your point on paragraph 6 is nobody walking past would see anything different once the extension's been turned into a separate dwelling from what they see at the moment. That's why you say it's irrational. But if somebody walking past can read the fact that there are two properties where there was one property before, then you can justify the conclusion in paragraph 6 that somebody will read what is currently an extension as a separate dwelling which is set back, and as a separate dwelling is set back incongruously. Now, he hasn't spelt it out in quite that way because he wasn't expecting us to spend 3 hours debating every word. But is that not a possible understanding of how the inspector gets to where he gets to?
I accept that is one pleasing gloss on what he writes, but in our submission, that's not what he's written. He identifies two separate factors which, independently of one another, create harm.
Yes,
and
yes.
one relates to plot.
The two things are you have narrow plot sizes and you have the building that's set back. Your attack on paragraph 6, which I think is the heart of your attack, because I think you accept that paragraph 5 by itself you can't really attack because the fence is partially visible. The inspector was entitled to find that the fence is partially visible. Your attack on paragraph 6 has to be nothing has changed in external appearance to alert anybody walking down the street to the fact what was an extension is now a separate building. That's an implicit premise in your argument. Well, explicit, I think. I think that is the basis of your argument, that you can't tell when you walk past that the building is now a separate dwelling. Because if you can tell it's now a separate dwelling, then the visual appearance of it being set back is a perfectly valid point to make.
I can see the force of that, my lord. But in our submission, it's important to focus on that which the inspector is actually concerned with in paragraph 6. which is not the plot width, which is not the plot sizes or the fence. It's plainly the setback from the established front building line, the prevailing pattern of development, and the appearance of subservience. Now, remember, my lord, that this is a building and an extension that has been part of the established building line, that has been part of the street scene, that has been there for over 14 years.
Yes, and there's no doubt the inspector's worried that, because he says that while this may have aided in the extension appearing subservient to the host dwelling when constructed, so he accepts that as constructed it's already set back. He's not making any facile error of thinking you're going to change the building line. The building line is what it is. It's going to remain the same. But he's contrasting, it seems to me, the way somebody reads that when it's an extension subservient to the host dwelling, on the one hand, where you don't read it as breaking up the building line because it's just an add-on to the main building, and the way you read it as a separate dwelling, which is his words. As a separate dwelling, it would appear incongruous. Now, it must be implicit in that he thinks that people going past would be able to read it as a separate dwelling. And indeed, your point is that they wouldn't, because nothing's changed in the appearance. And I'm trying to think of why the inspector has come to the conclusion that people would be able to read it as a separate dwelling. And the only thing that he says about the change in the appearance is the fence is partially visible. Now, he hasn't spelt it all out, but once you see it that way, it's possible to make a rational reading of his judgments, rather than, as the judge was forced to do, think that he has taken leave of his senses and said, nothing's changed in the appearance, but it now looks incongruous, which is a very, very odd thing to say. I ought to put it to you, because...
I'm grateful for putting it to me, my lord. I think that takes us back, though, to the question of overcomplicating matters. Sometimes, I think there's an authority, I can't remember what it's called, you know it's an elephant because it's an elephant. And in our submission, that tension that you've identified there, it's very strange for the inspector to be banging on about appearance and incongruity and matters when there isn't any physical change as a consequence to the building, as a consequence of the change of use. That is strange, and that's the irrationality. I mean, sometimes, my lord, it's simple.
As simple as that.
Yeah, sometimes it really is.
But there is a physical change. There is a physical change, and the physical change is the erection of the fence. And the erection of the fence is visible, according to the inspector's own finding. I mean, that's clearly implicit, isn't it, in paragraph 5. And once you, as to use my lord's word, can read the separateness of the dwelling because of its setback read together with the fence, then the scene literally changes. And that's what he's decided.
With respect, my lord, that's not what he's decided. He's decided that the addition of the fence would cause a variation in the perceptible plot widths.
Yeah.
And then he says that the change of use would result in a dwelling existing that would be set back more than the other dwellings. Those are, so if we were to think about the component parts that my learned friend has referred to, plot width, setback, building line, these are different ways of perceiving built development along a road. The inspector plainly does not identify the fence as having an impact on the building line. He plainly doesn't identify the fence having an impact on the building setback from the road. He identifies it having an impact on the plot width. And then when he comes on to paragraph 6, he identifies what he does think has an impact on building setback and building line, and that's the change of use internally of the building itself. They're two separate things, but in combination they result in the impact he's identified. And that's why it's important, my lord, in our submission to focus on what the inspector actually says, rather than in our submission going overboard in trying to make sense of it for him. Because alas, sometimes people just get the wrong end of the stick. And one means no criticism of the inspector in that respect, but it does happen, and this is one of those cases in our submission.
Well, Mr. Brett, we've put the question to you. It's none of our business to seek to persuade you to pursue a different argument from the one you are pursuing. We make that clear, but we're duty bound to put the question to you, and we've done that.
If I may make one point in response to a matter my learned friend has raised on a number of occasions, it was put to you in the context of the National Design Guide definition that because the judge below found that this wasn't a case about design, the National Design Guide was irrelevant. And now that's a relatively new point. It would have been helpful to have been able to deal with that in the original appeal against the local planning authority's decision. But the short point is the Secretary of State can't have it both ways. Now, when your lordships were discussing policy BE1, if you recall, with my learned friend, every single item of that policy is about design. Policy DMHB11 is about the design of development. If it's the case that this is not a case about design and the National Design Guide is not relevant for that reason, well, there's a whole other area of law here, which has not been open to us to plead so far, but that the inspector erroneously took into account a whole load of design-related policies when they're irrelevant. It doesn't seem to me that that's a submission that can have any force if the Secretary of State is going to maintain that BE1 is the relevant policy.
But if you're right that the inspector was making a visual point, then design is relevant.
It's part. It's if and that's our an additional submission there is that the inspector's fixation, or necessarily so because of the reason for refusal, on these design-related policies also point us towards a world in which he's thinking about the appearance of built form rather than the merits of a change of use, for example. He's not thinking about additional cars and coming to and fro and intensity of use in that way. He's thinking about what it looks like, what the design is. And those are the focuses of those development plan policies in our submission. So I wish to respond on that point. Otherwise, unless I can assist you any further, those are our submissions.
Thank you very much, Mr. Brett. Is there any reply, Ms. Pin?
Very brief, my lords. Firstly, I have checked benefits of PDFs. Street scene is not defined or even used at all in the NPPF. To be clear, that part of the National Design Guide, page 150, was not relied on by the appellant in front of the inspector. That was the material the judge found on his own volition.
Sorry, can I haven't quite understood that. We were shown that in the appellant's appeal statement he quoted the definition, and it appears to be exactly the definition which we've got at page 150, whatever it is. Are you saying he got it from somewhere else, or 151? Or what?
If I might assist, there are two pages at pages 150 and 151. Page 151 was before the inspector. You can see that at page 110 of the bundle. Page 150 wasn't.
But what you rely on is the definition.
Yes.
Yes.
And that was before the inspector.
Yes.
I'm grateful for
Yes.
that.
So I'm sorry, I've now not understood the point you were making.
Precisely what my learned friend said. Page 150 was not relied on by the appellant. If I've misunderstood the page that my lord took my learned friend to, then that's my mistake.
Sorry, page 151 was before
50.
the inspector, yes. The only thing is, 151 is an abstract definition of street scene. The only place I found it is on the page 150, but it doesn't matter for these purposes. It's the definition of street scene.
Right. And on that, my learned friend rightly said street scene isn't contained in the development plan policies because it is, as my lordship said, a trendy term. Streetscape, townscape are words of a more ancient vintage. Those are used in the relevant policies. So we see, and just for your lordships, note EE1, page 153, paragraph 2, uses the word townscape. 156, DMHV 11, paragraph A, Roman numeral 1, bullet point 3, uses streetscape twice, and 158 of the bundle, DMHV 12, Roman numeral 2, uses townscape. It's a generic term, and that the danger here is that streetscape becomes legalised, which is partly why we're here.
Do street scene and townscape mean the same thing?
They ought to. It shouldn't be legalised and limited to only what's used in the National Design Guide.
Is townscape a purely visual concept, or is it a broader concept?
Broader concept is my understanding. I speak as a lawyer, not a planner, and I wouldn't want to define it for those behind me.
Okay, thank you.
I'm not sure if I've addressed the point, so I apologise if I'm repeating myself. My learned friend criticised me for not flagging the judge's comment that design was plainly not relevant, and then arguing, therefore, the definition of streets in the NDG shouldn't be the limit to how it's used in the inspector's decision. I refer the court to paragraph 21 of my skeleton. And insofar as I've been criticised as attempting to rewrite the decision letter, that criticism is rejected. The Secretary of State is simply inviting the court to apply the correct decision-making framework to it. Doing that, one sees the inspector did lawfully carry out his statutory duty, and appreciating that there is going to be a new separate dwelling in place where there isn't one before, there is, as the inspector found harm, by reference to the factors set out in the development plan. And finally, I find it hard to understand how my learned friend can succeed given the concession made in response to an intervention by the senior president, insofar as he accepted that street scene in the National Design Guide itself, that definition includes factors which the inspector found harmful in paragraph 8 of his decision. So even on the case of the respondent, if the inspector had applied the definition in the National Design Guide, notwithstanding what's in the development plan, notwithstanding what's set out in paragraph 8 of his decision, his conclusion would therefore automatically be lawful and rational, even on my learned friend's argument. And so, unless there's anything further which I can assist the court with, those are my points in response.
Thank you. Thank you. We're very grateful to Council for their very clear written and oral submissions. We're going to reflect on our decision, and judgments will be circulated in draft in the normal way in due course, for the purposes only of typographical and minor factual corrections, not for any consideration of the substance of the judgment. At that stage, again, in normal fashion, we shall expect a draft order to be provided to the court, together with any submissions that are necessary in respect of that draft order. Again, in accordance with the practice now adopted by this court, there will be no need for attendance of counsel at hand down. The only other thing to say, which is important, is this: there will, of course, apply the normal embargo arrangements. Those arrangements are important, and any infraction of them is likely to have consequences. Thank you very much.
All right.